Everyone, my seniors, the Magyar Kosaka Director, Sri Surat Chetri, Law Secretary, London Judicial Officers, my colleagues, Ranjita and Suvarna, right? The London Bar members and the staff from the courts. So let it be an interactive session. We all are here, all the learned persons and the staffs who have been very much experienced with the technology that has been brought to the courts. So let it be more of a discussion rather than one-sided speech. I do not know everything, okay? Just like we all do not know everything, we need to learn from each other and let's be frank about it. The first topic is the brightness okay? Because from here I don't see it very clear. Can we give more contrast to it if we can, no? From that what we call projector. So AI in judiciary, this has been a topic of recent import maybe. We all have been, when it comes to technology, what I'm reminded first of is our Indian Evidence Act, our procedural laws, which were actually enacted somewhere around 1800. And CRPC, 1973, let's say prior to that somewhere, 18 something, as well as CPC, the Civil Procedure Code, which of course are known by different names now. Now if you go through this law, even the chapter on expert opinion and etc., that's my personal view, it's my observation, I find that the law still doesn't consider science as something which is, of highly acceptable as evidence in the court of law or in whatever manner it may be. Even on the expert's opinion, if we see that, how do we take as judges the expert's opinion to be reliable and acceptable in the court of law is that it's not the expert what he is saying that we accept. There are judgments which say it's the judge who himself or herself will analyze whether what the expert is saying does fit into your case and it matches with the rest of the thing. So even the experts are not relied or their evidence is not accepted just because it is said by an expert. The judge himself or herself will have to analyze it. That law is of very old time, I would say. If you see, these judgments came about when the most widely used science in the field of law was handwriting. The rest, chemical examination, all the ballistic and all that, it really came later on. Of course, some of the very metro cities did have the facility for examining ballistic materials and all, but handwriting was the most common. You will find most of the judgments in the expert field relating to handwriting. And we try to import that and put it into the scientific era of chemical examination, etc. Now sometimes a thought comes to me, if I am to follow these judgments and apply what is being said to chemical examination, so should I get the two chemicals in the courtroom, do the same experiment and believe the expert that, what he is saying, the color changes is correct. That is not done, right? So, science has changed. My point is, it's not that, we have to be what has been said long time back about this, about science in the field of law. There are so many instances when the science is disbelieved. Even for handwriting expert, the very first judgment that the defense would bring before you is that it's not a substantive evidence, therefore it cannot be relied. So on and so on. And you'll find a lot of judgments which says, you cannot completely rely on this. But I have had an experience of, I'll share this with you in deciding applying this principle in my own case, which had just one handwriting to be examined, one signature. Otherwise, if you go to residence cases, there are hundreds of handwritings to be examined, which is almost difficult for a judge to do the same what the expert did, because I am not an expert in that. But it was one handwriting, just one signature in a check. And the opinion of the handwriting expert was also not very voluminous. It was about 3 or 4 pages. So I could do exactly what the judgments were telling. You see his opinion, you try to see the handwriting yourself, and whether what he is saying can be true or not. And when I applied that, I I could rely on myself that what the expert is saying is correct. Because that was just a one signature, I could carry on the experiment myself, taking help from what the expert has said in his document. But if it is voluminous, we hardly do that. We don't have time to do that. Even if we have time, it becomes difficult to judge different types of handwriting from our viewpoint. But what I realized is that the science was true. At least even if it is 99% correct, and there's no better other evidence than that, the opinion of expert. So I feel that science has evolved, and we need to rely more on science to come to a real conclusions. But still the law is as it used to be, so there's a lot of argument and fight regarding this acceptance of handwriting or chemical examination, ballistic report, etc., etc. And we still consider, even as judges, that okay, let's look for some other direct substance evidence so that that will look later on. But to my mind, science has evolved, and we need to be more, I feel, we need to be relying more on the sciences which are giving, I think, almost accurate conclusions. A footage in CCTV cannot be faulted. CCTV shows something, and there's such a huge argument in the courtroom from both the sides that no, we cannot rely it because there's no 65B evidence, there's no this thing and all. But it's clear to me. In fact, I had that one case in North where the person was alleged to have stolen a ATM card from the house. The ATM had the pin behind it written, went to the ATM, took out certain amount, I think it was 2,500 that he withdrew. And that time, it used to be 100 rupees note. I think it's a case of 2014 somewhere. And you could get 2,500, 100 rupees note in 100 denomination out of 25 numbers. He counted exactly the same in the CCTV footage. 1, 2, 3, 4, it reached 2,500. The case was proved, but there was no 65B, so I appealed. I thought to myself when I pronounced the judgment that the accused was looking at me, he might be shocked. I saw him in the CCTV counting the money, all of the evidences were against him. But since CCTV the footage could not be proved, when 65B was not there, in those times they never brought 65B. It was not prevalent at all, at least in our jurisdictions. Some cases were decided without 65B even though the law was there. But that time I couldn't do so because the law said you need 65B. So whatever I viewed, in fact I could not have viewed it at all. So I had to ignore what I viewed. So the accused might be shocked. The judge saw me counting the money inside the ATM kiosk, the machine there. Still he appealed. And he was a chronic thief. And that was the only case that was coming so close to convicting. So I mean, yes, there are procedural laws, so and so, but had 65B been there, what difference would have been made? Just a certificate, I would have convicted. So mainly I was relying on the CCTV footage. But yes, there are cons to it, which will come later on. So now judiciary too is fast moving towards technology. Trying to use AI is something of recent import, though it was there long time back, but its prominence has grown now because it's being used. Otherwise, AI did not, just grew up yesterday and it has become adult now. No, it's not. It has a long journey from where it began. Initially, in the past we had websites. Now, if you see Google also today, when you are searching it, if you have noticed it, it gives a different type of results than the one it used to give before. Now it is more AI based. There are more chances of you getting the wrong information. So, in fact, last time, we get confused with the one thing, those who are not in the courts, regarding BNS and BNSS. Which is which? CRPC or the other one? Or the IPC, there is BNS and BNSS. So, I was once in the Honorable Chief Justice's chamber and we got confused as to which is which. So we Googled to get the both results. It says BNS means this, BNSS means this. That was one result. The other, the wrong result was also there immediately after that. So, the searches have changed. There was a time when websites were giving accurate informations. because the information was less. The internet, which connected with all the computers in the world, went to a particular computer where the data was there. It collected from there. That was the only data available, and absolute correct data. Now there are huge data. Okay, there are fake websites. Data is being pulled from anywhere. So what we get is we get varied results now. The variations are such that we need to be very careful now before accepting that as true. If you do we'll see that later on. If you do a Google search, the first answer which it never gave before was it gives from AI. Then it takes you to the various sites where the information you're looking for is located. Okay, that is one aspect of it. There are several AI search engines that have come, like in Microsoft has Copilot, Google's Gemini, right? ChatGPT is very famous, DeepSeek is there, so on and so forth. So are those things coming to us in the judiciary? Yes, of course. Artificial intelligence in the judiciary refers to the use of technology to enhance various judicial functions. This includes automation of administrative tasks, data analysis for case management, and AI-driven decision support systems to aid judges in making informed rulings. Now, AI just doesn't mean, in judiciary, one may think that when we talk about AI, a robot would sit there and decide cases, right? It's not that. AI is very, very vast. It takes into account making things easy for everyone. One fine day, though we criticize it, in the judiciary it is much more, it meets more resistance than anywhere else, because we have been traditionally dealing with books. We have a traditional system of going to the courtrooms, taking out a big reference books, reporters like AIR, etc. And we are still comfortable with the actual natural paper rather than the computers. But it has much more function. It's not just about judging. That will come very later in the last. First is we have manageable amount of cases in our state, but certain states have cases which are unmanageable. So can we do something about it? Because it's just one judge sitting out there and thinking, how should I manage my cases? So if we can give that function to the machine to think that how should I manage my cases, which are such use, which cases should I use when? What is the rate of disposal of certain types of cases in my court? So therefore, should that I take first, or should I concentrate on that so that my efficiency in dealing with those cases is enhanced? These are the support systems that AI can give, and I tell you, I'm very positive about it. It can do a lot of work which we humans will not be able to do. Who thinks in the courtroom how my cases are to be managed? The judges. We still don't have support system in the courtrooms who thinks on this line. Actually, we should have. The proper role, I think, of a court manager would be to think on this line so that the judge can concentrate on the cases. But our systems are quite different. We still need to move on very ahead to come to a system where a particular person will be doing a particular job. That's what this machine is doing. It's taking my certain jobs from me to do it by itself. Whether I can see that which particular case is taking the longest time in my courtroom, and do I need to improve on it? At the most in the courtroom I may sit and think, but I do not have that data, right? To reach to a correct conclusion that this is the case which is delaying my disposal. So if the computer can give me this many days you have taken to decide this case, or to complete evidence in this, or if it can predict that you are weak in this sphere, that's why it's taking long. Same could be for lawyers also, who have to manage their cases. So this is the places where AI can be used. Let's not jump into a robot sitting there and deciding cases for us. This includes automation of administrative tasks. A judge deals with various leave applications in a day in the courtroom or in his chamber on the administrative side, particularly the district judges. But what do the sections do? They have to see how many leave the particular person has taken so far. Let's say up to the month of May. And we'll have to write that the person has taken, the employee has taken 4 casual leaves this year and has 6 casual leaves at his credit, therefore he may be granted leave. And it comes to me as a judge. Now 4 casual leaves still, let's take example, someone has taken 8 casual leaves up to the month of May, that's quite a lot. Something comes to the mind of the administrator or judge, a person till the month of May has exhausted 8 casual leaves. Means there are still more months left than his casual leave at his credit. It's going to be exhausted soon. Leave is not a matter of right, I can reject it. Right? Though it works as a matter of right at our places. The person would not come also, the leave comes first, and the person is not there and granting leave. Whether grant or not, the person has already stayed, right? So we need to correct all these things, and these machines can help too. Now I as a judge may think that, okay, how many leave he had taken last year? If I ask him a section to give it, to see his pattern of taking leaves, his or her, then it will take another 3 or 4 days for the result to come to me. If I can automate this to the machines, at a click of a button, I know the person has a similar pattern for several years. I have a ground to reject that leave, which ordinarily now I do not have because I do not have the data. So data becomes very important. There are so many files. These are routine works, right? Leave applications. There are so many others on the administrative side, which are routine work, which I can delegate to the machine. I just need the result. Now one may think that, even when I was preparing this, I'll tell you one interesting thing later on. Even when I was preparing this slide, I thought that I lost my skill to work on PowerPoint. But do I really need that skill as a judge to be very expert in preparing slides? I think I do not need it. A human cannot have all the skills. Of course, we like to have all kinds of skills. Who wouldn't like to be a person who knows everything, right? That would be ultimate wisdom. But I don't want to become an expert in making a PowerPoint. That would be an additional help to me, though, if I would be expert in that. But what I need as a judge is I need strength in my job, not in someone else's work. Someone who is expert in making PowerPoint, leave that job to that person. So I thought if I would not know how to make a good PowerPoint, I would not be losing my job. I would not be, it's not a skill required of me. The skill required of me as a judge is to have good judgments, is to say, analyze evidences properly, reach a proper conclusion, be fair. These are the qualities as a judge I will need, right? So I'll be concentrating more on that. I'll leave making a PowerPoint to the machine. Let it do that job. I need to deliver. So this is the skill I do not need. Of course, I do need to present it. That skill must be there in me. But I do not need to really put these pictures and all myself and waste 3 hours in which I could have concentrated in my cases. So this is how AI is to be brought to the judiciary. Data analysis, I talked about data analysis for case management. I gave you the example. I need to see as a district judge how many POCSO cases I concluded within 6 months of time. Now to get that data now, I need to ask my staff to look for almost a whole bunch of files. He is a human, will take time and give it to me, okay, this is it. So it will help a judge in knowing his strengths and weaknesses as well, and to see where he can improve, right? I may be a certain expert in deciding certain cases, but I may be lacking in some others. So it will enhance the, to improve your strengths and improve on your weaknesses, right? Now the last one, AI-driven decision support systems. The Honorable Supreme Court already has SUPACE, a software called SUPACE, which is AI-based. It came about in the year 2021, and it does the job of which particularly relating to precedents. The most difficult thing for a judicial officer or a judge in the courtroom while deciding cases is to see whether that particular matter has been decided in the past by the higher courts, and because of that I am bound by it. That's the biggest data we need as judges. Otherwise, if we are left to decide on our own, then there will be conflicting decision overlooking the precedents that has been followed, or which is exactly applicable in my case, or which guides me to reach to a proper conclusion. So that is the biggest data judges need. So this toothpaste does that. It looks into the data regarding a similar case, whether some of the judgments have been delivered on that point, so that on the click of a button I have a whole lot of judgment which I know it says this in this context. So that saves a lot of time. To aid judges in making informed rulings. Now, what we are doing now, we have the certain reporters, such as All India reporters, Supreme Court cases, online systems such as Manupatra SCC. We do go there and get there and check. At least we check in Google whether there is any judgment on this point. Whether it be a very easy point to decide, because we have to know we do not conflict with the judgments that has come from the high courts, especially the high court from their own jurisdiction. So to see that we do go while writing judgments, whether the point has been decided or whether something has been said on this. And when we search it, we often get at least very close judgments to our facts. So, but if there is an AI which tells me step by step, guide by guide, year by year, on the exact words to, on the exact facts this has been said, then the work becomes easy for me. So AI can be used in this manner in the judiciary, okay? AI is currently utilized in numerous ways within courts, such as legal research automation, which I recently talked about, predictive analytics for case outcomes. Now this is one field which is still very, very young, where the predictive analytics. Now if we as judges or lawyers have, particularly for lawyers I guess, even we have relatives, right? They sometimes, most of the time they only talk for one reason with us. They have some case and they want to know what is going to be, and they want the absolute correct answer. This is going to happen. This is very difficult in law. And the thing that always came to my mind was, I could not predict the outcome of the cases, no matter how many times it has been decided in the past. I do not know, things are changing very fast. The precedents change very fast now. A particular bench or a particular judge may take a different view and deviate from, not agree with the past precedent. So to tell someone that this is going to be the outcome of a case would be foolish. We cannot tell that. But how far we can predict? And you will be predicting the outcome. You will be giving many options. This is likely to happen in a case. This is likely to happen in a case. So be prepared for anything can happen. But these are the things that are most likely to happen, right? So that is predictive analytics, which we are doing with mine. Of course, when the client comes and says, first thing they would ask you is what will happen to my case, right? They are not bothered about anything else. They do not know law. And the people whom we are conveying this is going to be the outcome of the case, they are also not bothered about the law. If we are wrong, they will tell the judge did not know anything. Oh, he is my relative, doesn't know anything. He told me this happened in the courtroom, right? That's an absolute possibility in law. It can happen anytime. So this predictive analytics, if it can be given to the machine, then it may be more or less correct, right? Because it is all based on data. But yes, future prediction, just like the predicament I had in telling my relative that this is going to be the outcome of the case, the machine will have too. Because still the cases are being decided by judges, right? So machine will be giving answers according to the data it has. As of now, the AI is still in the stage of machine learning. It's still learning. I tell you something about data, this AI began initially with all the data being collected. There was a time when we ourselves were discussing, now that there's so much of data leak, all data are being taken. Now we don't find that talk quite a bit. That phase has gone. Now we have accepted it, we have agreed to it, and we have started living with it. There is no way that your data cannot go outside once you are connected to the internet. It will definitely go. So more or less, at least some amount of data has been collected so that the AI can start its work. But it still needs huge data to be more accurate, right? So I'll be coming to that. So that is what predictive analytics is. What is going to be the outcome? Even a client would feel that. And let me tell you, there are chatbots which has been made even in India, which does the job of a lawyer. And there was one or two suggestions that I got while scrolling the social media, which said we do this. Okay. Now they are answering the questions. I do not need to go to a lawyer to know what will happen to my case. At least some basic ideas the machine is giving. Okay, that has already started. And let me tell you, as a CPC, I get so many letters from private firms saying that we have this technology to help you in this legal system. But when it comes all down to money, okay, and then I just shove it off as of now. E-filing systems, e-filing system which we have seen, that's not AI. Still it's a basic thing which we are filling data, but the aim, slowly it will move on. Because, let me tell you, recently Honorable, which I was expecting, right? The Supreme Court had e-SCR platform and one digital SCR. I was very sure, pretty sure some new things are going to come. So they merged the both now. So the improvement in technology, at least at the Supreme Court level, is very fast. They're moving from one step to another quite fast. It seems very small at the moment, but it's a progress towards something higher. Just like I said, e-filing systems, we have a very rudimentary e-filing system. One day, what is it going to predict what you should put in next? Okay, and if you have a similar filings which you have done in the past in your computer, it might ask you, should I peruse give me the permission to go through your computer so that I can find the similar filings which you have done. And if you say, let's say 4H2, same ground, same facts, just the parties are different. You name the parties different, just click it, it will generate everything for you, rest remaining the same. So this is the technology that these e-filing systems can move on to. If you have filed similarly before, you can gather information further. It saves your time from giving another input, right? Maybe you have e-filed in the district court, you lost the case, then you went to high court. You can pull the data from there. So this is the technology that the e-filing system would be one fine day. And the things that are moving so fast in the Honorable Supreme Court, this may come very soon, right? The jury selection, it relates to not our jurisdiction, right? Because how are the juries selected in the jurisdictions where the jury system is still there? It's human. So things are trying to move to machines. These applications aim to streamline court operations and improve access to justice. Impact on judicial efficiency. The integration of AI technologies has significantly improved judicial efficiency by reducing case backlog and speeding up decision-making processes. Which I told you, even the present AI which we have, still, if I can give it the data, it will give almost a very good information to me about my own style of dealing with cases. But I need to give it data. There is no independent software looking for the codes. Right? I need to go to some general AIs, give it the data and tell me. Yesterday I asked it to, while working on this, I asked to design a house for me. And it even knew that I was at Gangtok, though I have not given that information to it. And it designed a very nice house, a house that is good looking and suitable for hilly areas. I have given certain inputs. It can do that. You may not require architects or someone. If you are really good at AI, you will not need many things, even as on that. You can do it yourself. AI tools can quickly analyze vast amount of legal data, enabling judges and lawyers to make better data-informed decisions in a timely manner. For lawyers, I would say, I've been in courts, I'm given the same judgment, about 5 or 6 judgments on the same point. I don't need that. I need one. Give me one which is real and which I'm bound by it. So for lawyers, and lawyers also may not be intentionally giving me 5 judgments. They want to win the case. Anyhow, you have to win the case for the client. That's what you are there for. And you've got 5 good judgments, you give it to me. Maybe to that client. But you are still not sure whether which one would prevail over the judge, right? So if you can get a judgment by typing just your inputs, that this is the judgment, that I'll put one and the judge would be satisfied, that would be saving a lot of time. So it is helpful in many ways, right? Data-informed decisions in a timely manner. Many of the, if you notice, Of course, in the facts, on the basis of facts also the cases are set aside. But at times the cases are set aside because we did not have the information that we had to have in our judgment, right? And as the case moves on to appellate courts, it goes more deep. The appellate court would look in from the other angles. They may get other judgments which we did not get. So if we all get the same judgment, then there is less chance of things being set aside in the appeal also. First of all, why appeal itself? Maybe we reach an era when we have all this data, when the case is clear and cut, there's no ground for appeal. All the matter has been dealt by a particular court, and that could be time saving. Okay. So the crux is we will be moving into an entire different system environment. If not we, the coming generations who will be joining judiciary or as lawyers or judges or even as staff might look a sea change in the system that we may have. Role of judges. Judges are increasingly using AI-assisted tools to inform their decisions by accessing comprehensive legal precedents and statistical data on similar cases. This support allows for more consistent judgments aligned with legal standards. Because there are varied precedents. As I said earlier, if you can zero down to one particular judgment, which is the ultimate, then the rest is not required at all. So a consistency, as long as it is not changed by a higher bench, carries on. Various ethical challenges when integrating AI. First of all, if I give things to AI, does it take away from me whether I should study the legal materials myself or not? I think at the moment we still have to study it because what AI is giving everything may not be correct. There are vast amount of data, incorrect data in the internet. So these systems collect data from internet, from the data we are feeding, or from any other source to give a particular conclusion. So as I said, there are a lot of fake data in the internet from where these systems may pull it and give it to you. So as of now, we still need to be very careful and not leave entire job to the AI system. Such as ensuring transparency, accountability of AI systems and protecting the rights of defendants. If I go blindly with the AI as of now on today, then I might be giving a very long judgment as well. Okay? Particularly so when we do not have a dedicated AI system for the judiciary, which only takes data of legal standards. Right? We are still going to the general AI. Of course, there are certain AI being developed which deals particularly with the judiciary. I forgot the name. If I remember, I'll tell you. There is one company which is only dealing with the judicial materials, so that the accuracy of the AI system is almost 100%. Okay? It still says, it is vital to maintain a human-centered approach in legal outcomes. Now, this word human-centered may be a debatable word, but it still says that, especially in sentencing. Sentencing is an absolute discretion of a judge. Of course, to a certain prescribed limit of sentence, right? Whether you give 6 months or 2 years, a judge will always have reasons to write. So that speaks about human-centered approach. But in sentencing, if we use AI, as of now, the AI which we know, that will take data, right? A particular judge has sentenced so much in this judge has sentenced so much in this, okay? And it will deal with the data and give you some path. Okay, this is the sentence it requires. That does not have a human approach. A judge, while so many judges are here, while sentencing would look into so many factors, but it still is the mind which is saying, okay, give this much of sentence. Why 6 months? Suppose which may extend to 2 years, right? Why 6 months? I'll be writing by 6 months. If I give 2 years, I'll be giving the reasons 2 years. It is not data based, it is my mind based. That says it's still not there. But yes, the developers who are developing AI, particularly dedicated to judiciary, say that one fine day it can do that also. How machines will exercise discretion, that's a totally different thing, but it's not something impossible. Training of judges becomes very important, just like today is a lecture, right? I told you what is AI about. But actually working hands on it is a different thing. So such kind of trainings are very essential for those people, persons who are using AI, from the experts who actually use the AI. Artificial intelligence enhances legal research by utilizing natural language processing and machine learning algorithms. These technologies enable lawyers to quickly sift through vast databases of case law, statutes, and legal opinions, identifying relevant precedents and regulations efficiently. AI tools can significantly reduce the time spent on legal research. A very important point. AI tools can significantly reduce the time spent on legal research, which even we as judges and lawyers, we spend the time most on this. We on writing judgments, probably the lawyers on seeing what materials you need to say that your point of view or your claim or your written statement or your defense is correct and legally acceptable. Okay? AI can analyze past cases and predict outcomes based on data, helping lawyers formulate more effective strategies. For a lawyer, strategy is very, very important, which is actual advocacy. You need to plan the way you need to take that case. All cases are different. All judges are different. The laws applied are different. So lawyer also needs to go with a strategy. If it can help you strategize your case, but how to go about this instead of regularly doing the same thing. It's a very helpful thing. By examining variables such as case specifics, right, judge tendencies are very important. I think the lawyers would agree that the first thing they would try to ask or try to know, not only here, everywhere, is to which judge the case has gone. Okay? The judge would also be, showing a particular tendency, absolutely fair tendency and not a biased one. Okay? That how he or she deals with the cases, and lawyer accordingly approach that court. AI-driven analytics provide insights that guide legal arguments and optimize case preparations. This data-driven approach enables lawyers to approach cases with greater confidence. When you know, you have confidence, especially in law. If we do not know, even as judges, we would not have confidence. Okay? AI's impact on lawyer-client relationships. The integration of AI within law practices can transform lawyer-client relationships by improving communication and service delivery. Let's not assume a situation where we still have digital divide and people are still unaware about many of very rudimentary basic things of the internet. Forget about AI. But it is assuming a situation which will come with time even in our country, at our place, that everyone is technology literate. Literate, I'm using the word, not educated. Okay? Once you are technologically literate, then I can communicate. I may be doing many things. The machine has told me. Once I meet a lawyer, I will say, no, I have told this. When I talked over the internet with a particular thing, this was the advice it was giving me. Okay? It improves the communication between the lawyer and the client. Okay? It's not that, in cases, lawyers are always superior to the clients. It's a collaborative effort to, let the court know what you are trying to say and expecting a certain judgment. That's the pure form of legal profession, I would say. Instead of a one-sided advice. So if a client is aware, literate about what may happen to the case in the courtroom, though he may not be doing everything, but that can establish a good communication with the lawyer. At present, if those who are not literate to that enough, whatever lawyer would say, he will have to swallow it, right? Or even when the judge writes the judgment, the litigants may have to swallow it, not understanding anything. But if he knows a bit, he can do a bit of research and say, okay, no, the judge is wrong here, there's a different law out here, and approach a lawyer. That would be a very, good scenario for legal profession. The increased efficiency can enhance client satisfaction, a very important thing, right? It's not just about losing, it's about satisfaction at times for most of the people who are spending money for the litigation. And foster a more collaborative relation, because humans, they are not something unreasonable people. Losing and getting annoyed does not mean they are unreasonable. Many of the litigants may want, what to say, satisfaction even if he or she loses. But if the person is left midway after losing, then he is dissatisfied, right? And foster a more collaborative relationship between lawyers and their clients. A very ideal situation, which we don't have today. Global perspective, AI used in other world courts. Numerous countries have begun integrating AI into their judicial systems. Countries use AI for docket management and case prioritization. These applications aim to enhance fairness and reduce delays in judicial processes, showcasing the diverse ways AI can improve legal systems globally. Right? This is self-explanatory. Comparison with Indian judiciary. The Indian judiciary is exploring the use of AI to address systemic issues such as case backlog and inefficiencies. Initiatives such as virtual courtrooms and AI-powered case management systems are being piloted. We're still in the pilot mode. Okay? However, challenges such as infrastructure constraints and regional disparities remain, necessitating a cautious and tailored approach to AI integration. Recently, fortunately, I had an opportunity to visit Singapore courts, a tour organized by Supreme Court of India, and we were asked to write a report later on when I came back. Why I'm mentioning this is such as infrastructural constraints. This is the biggest constraint that I felt that we have in our system when it comes to applying technology. We fill the vacant spaces with our technology. But there what I saw was the design itself of the building accommodated the e-infrastructure. Now what if I get a computer or a television screen, I need to look in the courtroom where I should place it. There's no place. It's not designed that way. So I'll be placing at some, most, viable place and let it work. There what I saw was they placed it in such locations that it makes your things ease. So the infrastructure constraints are still used in our country to place. And look at this. I'll give you an example. Look at this screen. It's placed somewhere out there. That's the best place it has in this room. But there it's not placed in. It's placed at some. Let's say it's in the back, designed to place this with huge screen where I can see from here also. It's not occupying some extra space. The E-systems are already designed to place in a particular place. I'm not criticizing. If I see this AC, it is somewhere protruding outside the infrastructure. That's not there in those codes. Everyone said it looks like 5-star. It looked like 5-star because it has been designed in that particular way to make it ease, right? We still do not have this infrastructural thought process while building structures to accommodate E-systems. Regional disparities, of course, our hilly terrains still do not even have a proper mobile network. That is the best disparity example I can give. If you move down to plains, you will not have that problem. Is it something unconquerable? It is. We can have good networks. Why not? It's just that no one is thinking about it or putting those systems in the place where they ought to have put, and no one is bothered. You will lose network within a span of about 100 meters in our places, right? Necessitating a cautious and tailored approach to AI integration. So why this is important is, we need to have a proper infrastructure to accommodate the E-system, not to put it in the vacant spaces wherever available. A thought process in designing E-systems into the infrastructure is very well required as of now, which I don't think is a subject of architecture even today. Case studies of successful AI implementation. Successful implementations of AI in the judiciary can be seen in various jurisdictions. For instance, the use of AI in predictive analytics in the UK courts demonstrated significant improvements in resource allocation and case planning. Similarly, AI-driven tools in legal research firms have reportedly increased the accuracy and speed of legal work, proving beneficial not just to individual practitioners, but for the legal system as a whole. One more thing I need to tell you about the other jurisdiction which I saw is that the legal firms there, all the international legal firms dealing with arbitrations were based in Singapore. Why? Because there is technology. there is acceptance of technology, and they're still moving forward. They want to explore all the areas. The ease of doing things there is, I tell you, it's just, you'll be awestruck. Everything is ease there. From your normal daily life to some other things, the electronics have provided ease. Of course, with it comes other things, which I also heard that people generally don't cook there. They do not have kitchens because you don't have time for that. You generally eat foods from outside, right? But they have maintained the standards and all. So with these developments, of course, some other things come, which even when we think from our side, we may think that, that's impossible in our society. But yes, the things have moved on there. Future of AI in judiciary. I do not know whether a typical courtroom in future may look like this. A very nice setting, actually, not something raised bench, but everyone working together for the cause of justice. The future of AI in the judiciary is expected to include advancement in natural language processing, that's a scientific term for the AI machines, which could allow for more intuitive interaction. I am still typing. Of course, I think the Gemini, I'm not sure, but I'll have to try one. I heard that Gemini even accepts the language which we are speaking, and as a prompt for generating AI results. I have not tried that. Additionally, as AI technologies continue to, just 2 days back my computer team told me, as AI technologies continue to evolve, they may offer even more sophisticated predictive capabilities that can inform case law and judicial decision making, ultimately leading to a more efficient legal system. Has anyone used ChatGPT out here? Okay, ma'am. Yes, I'll ask what's your name? I forgot your name, so sorry. Mima, yes. What you have done, tell me. Let's be a little bit. I relate to this.
I used it for some of the research and also for some drafting of some essays and all.
Oh, give her the mic. No one from academia. What time do we have the break? I don't have the schedule here.
11:30. 11:30.
Okay. It's like, we are still in the beginning phase. People would say, oh, this fellow does not have brain. But I'll tell you, you have more brain than the rest in using this AI.
Yes,
those who are not using will be left behind.
Yes. I use the GPT in making my list of dates and events in repetitions in code. So it gave me exactly the same list and the same dates that I put in my repetitions. It was helpful.
You got what you wanted, right?
Yes. It was in our own hyper format.
Okay. Yes, sir, it will give that.
Yes.
It will write High Court of Sikkim and all.
Yes.
Because we have data online, right? It goes there to pick what styles we have. Yesterday I tried so many things, even I was amazed. Give to me, someone from different field, let's see what you did.
I've used ChatGPT for creating PPT first. First time I used to create PPT, and then afterwards I've done many. I've used ChatGPT for many things like for Madam I have created PPT for within 5 minutes. Really, Madam, she asked for me. So within 5 minutes I could create it and give it to her. I think she doesn't know that.
No, I don't think Madam is listening what you are saying, but
later on for myself I created another PPT and I created events I tested for writing the notes in the office, and I think one later also I created using this ChatGPT regarding WebEx starter that I wrote to user. Same that I used the ChatGPT, and recently I've attended this AI class, so I have learned few things from them.
okay, thank you very much. Anyone else? Okay, there was nothing wrong in ma'am asking it. I'll tell you something a little bit later on. Ma'am was, listening courtroom. JM Court is one of the busiest court at Canton. Right? I wish no one reaches there, some of them are there. But now things at least in the past it was really a hectic court. So of course, yes, that can be done, which I'll tell you later on also. Now why I ask this is, the future of AI in the judicial is expected to include advancements in natural language processing, which could allow for more intuitive interaction with legal databases. Now, more intuitive interaction means that you want something, right? If you are required to work hard here also on yourself and you're still not getting what you want, then it makes no sense. So these AI machines, even in a very short time, even ChatGPT has improved a lot. You will not be writing a whole paragraph asking it something. You'll be writing 3 or 4 words. That's your prompt. The better your prompt, the better the answers will be. But the world has known the common people's prompt are not going to be that very great. So the machines have to be learning in such a way that it's not someone expert who is giving the prompt, but some people who are laymen, right? It's still giving you what you want. At the moment, the more better the prompt, the more better answers you get. Just like he said he made PPT, right? He had to give some very good prompt to get exactly what he was asking. But these, intuitive interaction are going to increase in such a way that the 2 words may be sufficient for the computer to know what you're asking. Just like if you see in social media, sometimes what you are even thinking about, you can see it in your pages. It's not just that your thought went there, some kind of, your way of working in that particular mobile or computer, the AI has learned it and it knows what you are looking for, right? That's why it's giving you those. It is prompting you something to move ahead more. So these machines are going to be so intuitive that, sometimes you just, that may be an exaggeration, sometimes you may just need to breathe. The way you breathe, it may know that what you are looking for. That may be a bit exaggeration, but I don't think it's an impossibility. It will be such intuitive, right? You need not tell it much. It will give you what you're looking for. So that's why I said, I asked Mingma, so did you get what you're looking for? She said yes. Even at the moment, if the prompts are not good, it asks you more details, right? Are you looking for this? Of course, yes. And it has come to such an extent now it does not want me to write, yes, I'm looking for this. It itself says, just type yes. Okay, and I just have to type yes, it tells me. And do you need more on this? If yes, yes, if no, no. Okay? So it's giving you so many things. Interaction with legal databases. Additionally, as AI technologies continue to evolve, they may offer even more sophisticated predictive capabilities. It's not an impossibility, as I said. We may not have even thought about. That can inform case law and judicial decision making, ultimately leading to a more efficient legal system. Why would a legal system not improve if I'm having an exact set of things that I'm looking for? Right? As a judge, I will be looking for, okay, as any court said, any legal opinion on this particular, if I get the exact thing, now my job is done, right? He said he made PPT in 5 minutes. Addressing challenges and risks. Despite the promising potential of AI, this is of today, okay? This particular slide is as of today. Despite the promising potential of AI in the judiciary, several challenges must be addressed. These include ensuring ethical use of AI, safeguarding against bias in AI algorithms, as I said in sentencing, or I can remember an example of sentencing, but there could be many others, database-driven sentencing may be biased, right? The computer still does not know that it is deciding a case, or sentencing someone's life is in stake there, right? And maintaining transparency in AI decision-making process, just like what she said. Someone would say, I'm using ChatGPT. It's still opaque. No one wants you to use ChatGPT for doing your works, right? I do not know why they do not want it. They think, oh, it's not you, it's the machine, right? That's untouchability according to me, which is abolishing of system. There is a form of untouchability. In AI decision-making processes, maintaining transparency in AI decision-making processes, and no one wants to say it also, I use AI ChatGPT. Legal professionals must work collaboratively with technology. Okay? to navigate these issues effectively and responsibly. Welcome, sir. Legal professionals must work collaboratively with technologists to navigate these issues effectively and responsibly. So, at the moment, as I said, one of the biggest fear that we have in mind is, let's say we give the AI system to write our judgments. It may give a good one, we still need to work over it, but where does it go? Okay, the AI wants data. It will suck like a leech wherever they find data. It will stick to you and will take it because it needs that to improve on its system and make a system better and improve things for you also. So how it may be misused, we do not know. Okay, I'm not thinking of a system where some particular, aggrieved person would go and change some words in the judgment and convert conviction to acquittal or vice versa. That's too meager a thing for AI. Someone only interested would do that. But would this data be used in a larger perspective ethically or not? That is the biggest concern, that we are not someone changing our conviction to acquittal. No one has interest in that unless the fellow is so much aggrieved. That's an offense after all. And we cannot, police or system cannot be every time with a person to stop him from committing offense. So the larger picture is how these data are going to be used. We are absolutely unaware. Okay, for AI also, what future it's going to bring about. Okay, so that's one of the things which we as judges may be a little bit of worried about putting our facts into the AI system, but it needs that so that it can give more predictive technology. The solution the world is looking into is making a specific AI dedicated for judiciary with all control mechanisms, so that if anything wrong goes, the particular firm, whoever has manufactured, can be made accountable. So general AIs for doing, writing things as big as judgments are confidential until it is pronounced, right? May be a risk unless we are provided with a particular software officially recognized with all security within it and a way to make the software or the person behind it accountable if something goes wrong. Until that comes, we may be still worried to put our facts into the AI system. I am telling you, you can try one judgment. No one is concerned about your one judgment. Okay, you may try one fact of disposed of case. I think it will give you more or less 70% of what you have written, given the Indian law, which is already knows, right? You can test that. But yes, as I said, judicial is still not bothered about conviction being acquittal or acquittal being conviction. But in the larger perspective, there are no laws also which restricts the data being taken by AI. Not laws in a sense, specific laws we do not have. Still, laws need to evolve. AI is evolving faster than the law that we have. And in technology, our laws are still very rudimentary. What to say? The cases are still being fought about whether the encrypted data of WhatsApp needs to be based in India and given to the government whenever it's asked. We're still fighting over that. This is a much bigger issue than that, about the data that the AI might take. There are no specific laws, okay? And the servers are everywhere in the world. So the more tougher law we have, the more difficult will be for these AI systems to work better. It needs freedom actually, to be frank. Long-term implications for legal professions. The integration of AI into the legal profession is set to fundamentally change the role of lawyers and judges. As routine tasks become automated, just like my signature in certain leave applications, which I need to write and mark it down, right? If these become automated, after my extra works are gone. Legal professionals will need to adapt, or the office entering which file move to which section in the registers, if this can be automated, and need to adapt by enhancing their interpersonal skills, strategic thinking, and specialized expertise. This is very important. We just can't use technology if we do not have knowledge, or sometimes even half knowledge. That may become dangerous. Ongoing education and training in AI and technology will be crucial for future legal practitioners. So conclusions are, as Mr. Milan said, this PPT is completely made by AI. And some of the prompts are mine. Of course, I cross-checked it, and it took about maybe 20 minutes. 30 minutes for me getting this and cross-checking the data. So that's so good about it. I did not, it would have taken me, if this was to be done really, putting these images, the resolution it has, these colors are not chosen, like the background it has, the fonts it has. This is all the tasks of AI, including the pictures of them. Okay? So it saved my time. Presentation is mine, speaking is mine. As Saul put it sometime, बोल उसके something I forgot. सब मेरे है वो बोल उसके, this type of emotion. This is made by AI, I've said that this is the future of legal technology. We may run under it, we may do anything, but one fine day, we may not see our coming generations will definitely using a lot of technology in the courtrooms. We may retire without it. I have no doubt also about that. So do we have any discussion? The credit is there last. It's called Slideshow. It's free. But if free person can do that, because I'll tell you one thing, everything comes down to money, okay? This AI and all. The more it's a business also. No one, because I'll tell you, if you do the Google search, you'll find that, how much work is required to do this much. It says it requires lots of water, gallons of water to, finally make those chips, which I put into the AI systems. So there's a lot of cost behind AI. And people are investing and doing business. This is the free version. For paid version, I could go with more number of slides. It is restricting my number of slides. So it's trying to fit in everything within those slides. So that's why I said I didn't get actually what I was looking for, but you can get it if you pay some amount. I tried to pay also, it didn't go through. I thought let's have one subscription of a particular AI which makes the PPT, saving my lot of time. So do we have any discussions on this AI? I spoke a lot, and like we may have certain views from our learned judges, senior judges. So that's and our additional. Yes, sir, why not? Your
We are also the master trainers.
Yes.
We are also the master trainers, but we have forgotten many of these things and we have not improved ourselves these days because we didn't get a chance to participate in this kind of trainings, and we have not improved in the way we should have been.
Yes.
Now you are there as a CPC and you are dealing with all these AI-driven softwares and all. So in your view, which software is the best in the market as of now?
So I would still say, I tried DeepSeek also. I do not have a specific answer for this, but I'll tell you, I tried ChatGPT. I have an account in ChatGPT. I've subscribed there. I tried DeepSeek. Adobe is also having a particular PPT presentation, which I tried yesterday. There is Gemini also. There is Copilot. I think all these ChatGPT came as something to do something in AI. Now only after that, even the Google was not doing it. Gemini also came later on, right? Copilot of Microsoft also later on. All these are actually commercially based. Of course they are working on AI, but they want to earn as of now also and move forward. So the results, yesterday even I checked it, which one gives me the best result. The Gemini and Copilot could not make a PPT. It could make a PPT, it could give suggestions, but it could not make actual PPT. ChatGPT still does it. So far I have seen the answers which I have got in detail is from ChatGPT. So I have got from there. But of course I have not used Gemini and Copilot to the extent. Just yesterday I used for a while, but I still felt that ChatGPT was giving me more things which I want than the rest. Thank you. It has been long that has not been in touch with, because even though I'm a master trainer, and I've been in touch with because I am a CPC Yes, I think this growth of the e-knowledge and e-system working into it, fitting into it, does require certain kind of environment. The environment which we have, we all of us have desktops in front of us, but it's still new. As Saw would put it, one of the master trainer from one of the state who had come to do the master training at somewhere in outside. He had bought his laptop. It was still in that cartoon with all those plastics, and he opened it there for the first time because he was supposed to go for training somewhere outside, right? So yeah, we understand nuclear physics or the science behind atomic energy for education and public. But see how clever it is. I can explain those topics safely and responsibly. Would you like me to explain how nuclear fission works? It's still teaching me, right, to make an atom bomb. But it will not say directly because that it cannot do legally now. So clever person who can give a good prompt can reach to what you want. The fellow will know I need uranium and plutonium, right? Neutral collision. Now you can go very deep in this and it will give you answers. So a good prompt is required, okay? Let's not write this bomb also, but I'm writing
title. So exactly what it means and the component is also exactly.
What size is this also?
What size is
that the complainant respondent number 2 has lodged a FIR against the petitioner alleging some minor only changes and conversation 3 that the allegations listed in the FIR are false, concocted, that the continuation of the present criminal proceedings are. These are user lines, I can still make it more better one by giving it more prompts. यो त भयो 10 मिनट त सेभ भइगयो यसमा. Would you like me to provide a sample affidavit? Nowadays this AI is asking some more things because it has known that now affidavits are also required. Okay. Earlier I did not know that an affidavit is a part of a petition. Nowadays it knows. Let me see whether it has asked me more or not. Now this grounds one, this grounds specifically followed in High Court of Sikkim. I had an opportunity to meet one lawyer who had not written ground, and therefore the Honorable Court said, no, you make another one and come. Though his petition was very good. But this grounds, I think is very quite specific to Honorable High Court of Sikkim, where grounds for quashing, grounds is taken as something different. One more is there, I do not know if the lawyers will know, in that petition or something. Grounds is one particularly looked for in petitions in the High Court. Now what is the other one also? Even though you write it there, you need to mention some things and grounds for that. I don't remember exactly because one lawyer had come because he practiced somewhere and he said, I mentioned it somewhere else, all the things.
This previous writ petition has not been filed earlier and in other high courts. Yes, what approach the other high courts or this high court? Same part.
That could be one reason, but what he told me was his facts were already there in the petition, but the court wanted me, the grounds were there. He had not specifically mentioned grounds. So the court wanted specifically to mention ground and all. So it has picked up. Probably there, even under e-filing or somewhere, we may be having certain petitions of High Court of Sikkim online. Some may have put in images or whatever it is, so it's gathering from there.
Procedure to this.
Now anything else, let's see how it does the same. That last time someone said, which students asked, which one works better. Let's see Gemini. I will ask with the same question. Honorable Chief Justice and his companion justice of the High Court. This goes more to a regular format, older type of traditional format, right? More on the Indian side. Let's ask co-pilot. These also give the user format. Unlike Gemini, I do not know why it is giving this. maybe there, but still we have the contents, right? How much, this is not better than the ChatGPT and the Copilot. So all of them are doing quite different. This says a plain reading of the FIR does not disclose the essential ingredients. The others are not saying that. So it depends on the way these, the AI machines have been made to work. Their focus could be somewhere else, but you do not build just an AI machine or software without any intention, right? There are certain intents behind all this AI machine, and no one wants to be similar in this field. One has to have edge over the other so that they grow. So as Sir would put it, all of three would be different, but ChatGPT, to my understanding, is much better than the rest so far, because it began quite a long time back. We usually find now the banking systems have this very good chatbots. Nowadays, even if you forget the people, you need not really talk on the IVR with the person there, unless the problem is quite complicated. Nowadays, you can just by talking with these chatbots, it solves your problem. That would be really good in for the legal system also if it comes. I'm very positive about it. Of course, it's criticized a lot. It's better not to speak there, but I think it is very helpful to us. So now we'll move on to eCodes project. All of us know actually what is that this session has already been conducted with the judicial officers last time. So those of you who were not here in the last program, right, we can talk some about. I'm not going to detail. We all know about why this. In fact, we talked during the session for the AI that why technology is important for the codes. For the rest of the places, we are already using technology, right? One fine day, when of course this AI and all these things are criticized, but one fine day, and everyone talks about data privacy and all. As I said earlier, it's not about someone changing consent protocol or something, but about a larger thing, which even when we criticize, we do not know how these data are going to be used in the future. E-committee also, we all know, it was actually it began somewhere in 2000. The eCodes project is actually the initiative of the government of India, where it wanted to digitize the codes even. So 2000 until 2025, 15 years? No, 25 years, right? We have been on this project. The ultimate aim is that, of course we do have differences between different jurisdictions of the High Court. That's what presently on the CIS we are struggling with. There are various nomenclatures at different High Courts. Some name it differently, some name it. In fact, there are public interest litigations in the Honorable Supreme Court concerning this. That having different nomenclatures is not good, because a lawyer out here, if you want to see a contempt petition, if it's written something with some C something out here, I think contempt, bracket C is here. Somewhere they may write CO or CT something. So a lawyer out here would need to try all those abbreviations to find out what it is called in a different court. This petitioner says it's a nuisance. So what he has suggested is let there be numbers. If it's a contempt petition, if it's 9, you may have different nomenclatures, but give number to it. So that if contempt petition is 9, called 9, it will be called 9 in the entire country, and let me be able to search it with number 9. You write whatever you want. You write CP, CT, we don't care, but give it assign a number so that it's uniform in the entire country. How that will help is we will have uniformity also, and because the different jurisdictions have a long history of practice, and changing it overnight would be difficult. And the question of jurisdiction, the administrative domain under the constitution also comes into play. So no one would readily agree that, okay, I'll change it tomorrow for you, but they won't say that. So that is why there is a PIL in the Honorable Supreme Court pending on this matter, that we need different nomenclature. Why after this topic is interlinking of all courts across the country. We need to have a similar prompts to find details in the courts. Now we have different ones. even we don't know what a particular matter is called in another honorable high court. So the future is we need to have something, one system, so that because technology, of course it can work with different nomenclatures or different systems. There's no problem with technology. It's just about a matter of writing a program by some software programmer. But why to waste energy in doing so, writing something different for different works? If you can have a one uniform software for all the needs, then it's the work becomes more easy, and you don't waste time writing different programs to meet different circumstances. And to make the justice delivery system accessible, no doubt we all know this, the more the technology, the more anyone can access things. E-Seva Kendras, as we all know, this has been here since, in our state since 2021, I guess. After the COVID, we have established E-Seva Kendras in different places. Of course, practically its functioning may be different with different jurisdictions. Gangtok, which has a lot of cases, the employees here may become more expert in dealing with the things and may know more, instead of someone sitting in the wrongly where the cases are very less, or some such jurisdictions. So it depends, but its primary job is to help the citizens. In future, we do not need this E-Seva Kendras as such we have today. If someone can utilize it via E-Seva Kendra, someone can just go in and do what job is to be done there. Instead of keeping a human there to help you, if the technology literacy becomes of reasonable standard, then someone can enter, and that's not that in Singapore. No one, of course, there were help desks with humans, and those were rarely required. There were computers which said, it's just like AI. If you have entered the court, for what purpose you have come, if you are lost somewhere, go there and type it. It will try to help you. Okay, next, what do you want? Just like AI is asking. So they could find their ways, right? So that was the system then. We still have a long time to reach there when our E-Seva Kendras will be manned by no one, but will be automatic so that the people could go. If you know the technology's basics, you don't need a human there. Okay? Okay, let's see e-filing. I want to do e-filing. Okay, go to this particular desk. Do you have it in the pen drive? Yes. Okay, insert there, do this. It will automatically take it, right? So that is the future that the E-Committee also envisages for the. But to begin with, we have E-Seva Kendras. Of course, training programs are quite important to know things and to build the capacity. Scanning and digitization, one may not see it. This thing works in the background in the codes, okay? The scanning and digitization process is going on. Though there are SOPs which we have to meet. Maybe we have not met we have not complied with the SOP 100%. Some are quite difficult to comply, but my team is there. One fine day when I became CPC, this SOP was put before me. How should we scan documents, right? And the beginning process, I joined only on 2022. Okay, scanning and digitization was going on a long time before that. But I thought at that point of time, why SOP is required? Of course, uniformity is there. And then another point was because the districts were saying that the SOPs are difficult to comply. We have not complied in the previous digitization. The data remains as such. One fear I had that time was that what if these parameters are required one fine day for the software under which we have digitized? I think that is coming to be true now. I don't remember exactly, but somewhere I found that the SOP which was given, that is so important that one fine day only those digitized documents are going to work in the software. Rest will not work, we'll have to re-digitize it. So I get a lot of queries from the district, this is not going on. Try to stick to the basics of this digitization, right? Especially that, why 300 DPI? Everyone used to say me, even I obtained opinion from my computer team. They said 200 DPI is more than enough. It's one of the best, okay? But I was still apprehensive of what they were saying, and that's coming to be true. They have said 300, it means 300, because one fine day, only this 300 DPI standard documentation is going to work in the software. The rest it will be rejected by the software. So that is why these are given. So my only concern, the rest are quite workable. But 300 DPI, it's a thing of resolution, right? So please stick to this 300 DPI. Anything less than that might be a trouble in future. You don't, resolution is something very different than rest of the parameters. Okay? So let's stick to that 300 dpi. It takes a lot of space, but right, we can work on that. And we have a lot of work to do on this. You know, on the scanning and digitization, what I see as of now is let's finish this digitization, right? Because technology is changing. As I said earlier, that so many things are being merged. Even within months, we make something better comes, and we are merging it or creating a new one. So this digitization will be a continuing process, even if we have not been able to adhere to some parameters. We'll have to do one fine day if that is required. But let's finish this digitization. Once that is done, we can move on with the destroyal of records. And to be frank, it's destroying of records it's not just possible for me, one person, or my computer. A collaborative effort from all the districts is required. We have too less manpower at the moment to destroy this. Destroying a record means someone should know what the person is destroying. That is the extent required. It's not so easy. Digitization and scanning is not an easy task. It's a very difficult task. It has to be perfect so that our e-records are there, and the next step would be destroying the old records. But if you destroy it and you have not scanned it properly and the pages are missing, and one fine day someone might ask the documents, we are in trouble. That's why the rule says 30 years, after 30 years destroying can be done. But according to me, 30 years is too long a period. Sometimes I feel it should be subject-wise also, like, why to keep bail matters which have already been decided a long time as a physical record. It is not required anymore. 482 petitions, okay? Condonation of delayed petitions where the petition itself was rejected and the case was never registered. These are all not required. No one would ask for it. Even if they ask for it, it's not such a vital document that legally they may require it, right? So these are subject-wise also, we may see that which records to be destroyed, because scanning and digitization is pointless if we are not destroying the physical records. Paperless codes, we are starting with it from the commercial codes. How successful will it be? It's all upon the judges and the lawyers who are in the commercial codes, right? We have already given touch screen monitor. It's a computer only. It's just a monitor. CPU you still need from a different desktop. But we have given Wacom, and to be frank to you, we may be one of the few high courts and the district courts who are having Wacom. Okay, and recently there was a questionnaire also. Someone asked in the parliament whether Wacom has been obtained by any of the courts, and I felt very nice when replying, yes, we have Wacom. Many of the and it's in affidavit. Okay, sorry, it's not in parliament question. It's an affidavit that has been put before the Supreme Court, and we are saying we have Wacom. So why Wacom? Okay, there of course I technically do not know how good it is. But everyone says that is one of the best if you can use it, the features which it has, okay? The touch sensitivity, it's one of a touch screen monitor which may not have parallel when it comes to many things. And someone recently also, I won't name anything, so just see the perspective. Someone said there was one desktop, I think it's Dell or something, or HP, and on the side it was a Wacom, okay? Everyone said that the display of Wacom is not good. See, Dell, it's so bright and giving such a nice quality. Once even I thought, did we really got Wacom? I have not seen that screen. I was on the other side, okay? So I thought that is not possible. We have paid 1 lakh something, almost 2 lakh for that, just a monitor. And there's one desktop which is about 56,000, which everyone is saying, yeah, it has a good display than Wacom. So I just observed that even I could see that it was a very good display. Just like we had at some point of time we had this selfie cameras which could show your skin to very smooth and all. I was finding the person there very smooth and looking different, and the color I could see it was so bright. And I looked at the person's clothes which he was. It was quite different. The color here was very height, okay, very good contrast, all those things. And later on I had an opportunity to go. I said, okay, show me what's seen in the Wacom. I saw Wacom was giving a very natural color. Now the very reason of that monitor is you'll be working on it for quite a long time, and the resolution it adopts, the colors were so natural, it will not strain your eye to the extent that other PC would have. Okay, so the purpose is different. So I explained to the person later on, this is what I saw. This is the difference between the two. In fact, the tie, your tie, which I could see naturally, and in the Dell PC was so different in color that it was looking something unreal. So that is why. One of the things I found there was it will not strain your eye. Of course, it will obviously do to a certain extent, but that's what it is meant for, right? So don't compare it with the other 65,000 Dell and this just a monitor costing almost 2 lakhs. The resolution is different. Of course, this is still a lower version than what we have presently, the better one in the market. That was what we could get. Paperless code will be starting now. There is one software which will be implemented soon in this course. It's from e-committee, which will directly fetch the data from the CIS. So there will be no papers. Of course, it depends on the judge sitting, presiding over that code to insist on this to work, because if you do not insist on this being work, no one would. Everyone would try to stay with what they have with them. So it will fetch the data directly from, let's say a commercial case is filed, even e-filed, it comes to the CIS, that particular software will directly fetch the data to your computer. And once it's registered, you'll see it's registered and you can start the proceedings from here. What's the next step, okay? So we are starting with paperless codes. And all the paperless codes except Pakyong and Soren, I guess, have not been provided this because we had a defined amount of items. Of course, we gave it one to Judicial Magistrate East Court, so that, because that court has quite a lot of cases, so that, a magistrate court also starts with it. Of course, this year I think we'll give it to Pakyong and Soren as well for the commercial courts. And gauging commercial court at the senior division also does not have a Nanchi got it, no? Yeah. And it's not that we are starting later on, if I could add to that. And this is the paperless court software for the High Court. This is our own software, okay? But for the districts, we'll be using the digital court software that is being provided by the committee. Of course, we can use this also if we have a better one, but we need to improve a lot on this. The lawyers who are in the High Court may be knowing about this. Have you ever used this? This can be used. I think it's the lawyer's desk also provides this feature in the High Court. I think some of them have logged in and you can see the case. This is actually used by the judge dealing with the paperless courts. But this is one of
we are getting the access, but only in the court time.
Yeah.
But it's only in the
Yeah, I understand. That's absolutely true. We can develop on this, improve on this. And later, of course, later on in the future will be that even lawyers would get to see this from their homes. Except those windows you will not go, which is exclusive for judge, where his writings are saved, his notes are saved. Some of the states, I think southern states, Kerala already has given this access to lawyers also. And I'm happy about to hear from my computer team that nowadays in the High Court, the e-filing is 99%. Even in district, it is quite a lot. So initially it was quite a resistance, but now people, and the younger lawyers, to be frank, they are very much keen on e-filing. That's so easy for them. Maybe the seniors won't find it, okay, you do it, right? But for them it's easy, They find it very easy. That's why they go for e-filing. In fact, sometimes so many lawyers come and say, see, I have registered for e-filing, but mine is not being accepted. And so it's so, I feel so happy to see that they are coming with it. We are changing. And High Court, 99% is e-filing. It's so easy. But what we still need to inculcate it, because why it is 99% so by lawyers are, because you are giving it to e-Seva Kendra and they are doing it, right? But to e-file oneself, it's much more better instead of giving them. As I said, if e-Seva Kendra in the future may just have a computer, you go and do it there, right? These are the portals. E-filing services. E-filing, we all know, especially the lawyers know and judges. Only thing that judges need to know is once it is e-filed, it comes to us, it's consumed, and then we can gather the data from there for the software of digital courts. As I've been saying it again and again, even I'm not finding a way out. If someone could find it, they can tell me the problem that comes is with e-payment. I need to put it directly to the treasury, which is not happening. In fact, recently what I discovered, to my horror, was that what was paid, all the fees that were paid in e-filing or fine, whatever it is still there in SPA. It has not traveled to SPS because no one knows it. It's a very small amount. I think about 25 lakhs something is there, still there. I may not be sure about the amount, but somewhere around it's there. And SBI has deducted so many charges from that account. Like somewhere it said non-maintenance of balance something. So, but that account was not meant to be so. Okay, so we have returned to them and give us the reasons why you have deducted these charges. About some thousands is not there. And this came to light when someone asked for refund. Okay, and then when it was processed, we found so many things out there. The money, entire money since its inception is still there. This is the biggest problem, how to link with this state treasury. If had it been a big department earning lots of revenue, this would have been solved. No one is bothered because we, from since inception, there are just some lakhs out there. So this is the problem. Otherwise, once the virtual court, we have concept of virtual courts. If it comes, the payment should be so easy. Now, and everyone was telling to the computer, sir, now you will do something. I said, we are not going to do about it. Our job was to make the software. Who carries the money from SPI to SPS is none of computer sales business. So we send the file to account section. So as I said, everything somewhere the computer is involved, they try to say it's computer sale. We have to be very firm on this. That's not our job of carrying money from the account. And what deductions were there, that's none of our. My computer team are very good. Okay, they were so serious about it. They can, no, somebody must do something. I said, we are not going to do anything like this. You send the file to account section, we have made a software, our job is done. We can help them, assist them if they want to, but primary task of why that money remain there is of account section and not of computer cell. So, whenever you get a chance not to put foot in some places which is not your domain, please avoid it. And I'm telling you the computer team down there. You do your job. This is that very thing. E-filing one, I will not tell much. Lawyers, Mr. Dungal is expert in e-filing. In fact, someone was telling me, also a master trainer, that no, please tell Mr. Dungal to do if there is any requirement of resource person, because he is keen on it, and because of course computer is this one. If you are keen on it, you will know more. These are the dashboards. Lawyers are more familiar with this than the judges, because we do not have our logins. Our computer section does have one, and dummy login. We will not waste time on this. This district team would be knowing more. Right? Consumer data. I think the police, the CCTNS side is also moving quite fast. I am in one of the committees in that CCTNS, ICGS, and they also have got. See, the question comes to money only. Why the CCTNS was not being functional, was not functioning properly? Is that because of course you need funds, right? So recently they have got some funds for some work. We have already started the civil criminal processes, right? As it started, of course I could, last time I got a mail which said that the Sikkim's queries are still not resolved yet, addressed to someone else or some technical person. I got a CC, okay? So there may be problems. I do not know if anyone of you can tell about it. Just like we had, end step for criminal processes, now for civil processes, as well as for criminal, instead of the court inspector marking it, forwarding to this court and all, it will directly go to the, I think what they have done is they have given the login, they have requested for login to SP and DSP also, which was not there earlier. From there, I think they will send it to such a police station, but still they will not be delivering it as of now in our state or through handheld devices. They will be printing it there. So the court is, the middle person, the court is gone, but probably there will be the CI only will be using the computers there, I do not know. So as it started, yes, Mr.
So Gangtok.
Yes. Oh, you are the pilot, no?
So Gangtok.
Tell us something about it.
So right now, what's happening is we are in the integration phase. Integration as in Gangtok CIS is being connected to CCTNS using our ICGS program, which is the CIS module. For the court end, there is no requirement for us. Sir must be aware, they were just the process of enablement. Yeah, that is done, sir. Now what is happening is, we have been very in touch with this CCTNS team, and the CCTNS team, they are able to consume the data that is being sent from our end. Our end, as in whenever we file a case, if it is a criminal case, the police stations are fed automatically. Say for example.
Okay, directly it goes to police station.
Yes. For now, it is going directly to the police station.
That's what. Just hold on. You can complete. You can continue. But just give me some. That's what I didn't like. What the CCTNS people wanted. It must go to SP. At that time, I did not realize it was a meeting. I thought, okay, it's a good process. Now, if it's going directly to police station, someone is the business of SHO. The CCTNS team from our state were talking that there was no logging of SP and DSP. They are a part of the system. Obviously, they may be a part of the system. Now, when I look in the hindsight, but if it's going directly to SHO, well and good. Now, involving two more middlemen in technology, they may or may not, because if we involve them, it may not go directly. They might have to press some button to release it to the police station. I do not know, but I think it should go to the police station. It saves a lot of time.
Delay the process.
That's what.
We have more men.
If we use technology, thinking that okay, we are a part of the system, we need to be a part of this. Even for someone, that's maybe with experience, the other side will also realize that no, let's do it with PS. But how do you ensure that it reaches the correct police station?
So what happens is whenever a case is filed in the CIS or for this matter, we have an ICGS program where the police stations, they upload the FIR and charge sheet. So whenever they upload it, if they are uploading it from a particular police station, say Sadar police station, then their data is recorded. A police station code is there. So that is how we capture the police station.
Okay, can we change this police station to send it to somewhere else?
No, sir, that is not possible. Because it captures the police station code.
Okay, that I understand. When you all are releasing the summons, what enablement you said process, right? So it is automatic that it goes to a particular police station.
Right. Or for the matter, the IO. Wherever the IO is assigned, it goes to that.
But that's quite weird according to me. Let's say the person is from Siliguri, right? Or let's say that's outside jurisdiction. Let's say the witness is from, let's say the accused is from Pakyong. Okay, then the case is of Namchi somewhere. Or let's say of Gangtok. Now, that's what happened in physical processes which I realized. Now, why should I send it to Gangtok police station? Just because it has the FIR? The summons should go to the jurisdiction where the person resides. I think we'll have to take note of that, and there should be a flexibility in deciding.
That's the reason why it's going to the SP. SP has a copy so that he can release it to the concerned jurisdiction where the witness resides.
Yeah, if they would do that, that would be very good. That would be.
There'll be accountability also, I think.
That would be very good. Otherwise, just for the sake of sending there, because that will be a huge issue which I faced in physical summons. The person resides at Namchi, I'm sending the summons to Sadar because the case is of there. And the Sadar would first forward to Ranipul, and Ranipul would forward somewhere to other, Jortang or somewhere, and the time it doesn't reach Namchi at all, and my date has come. The summons should go to the jurisdiction where the person resides. It's as law is as simple as that. So we need to look into it, and whenever we get opportunity, we need to mention that flexibility must be there. Okay.
So actually, what we are suggesting, because from practical experience, the court is suggesting that the court inspector actually should be the allocator.
Yes.
The reason being, sir, if you go to a police station, say for example, we have a problem with Sherathang also. Sherathang, if they need to upload the data or they need to download all these police summons, the problem is they do not have internet service. Internet no problem, and then they do not have NIC lines, sir.
Yes.
And to take nickname from Gangtok to Sherathang is a lot of money, sir.
That's impossible.
So what we are suggesting, it's a very easy process, sir. What we are suggesting is put the court inspector in charge of allocating, because the court inspector will have up-to-date knowledge of.
But court inspector also, how will see avoid Sherathang if it's of that PS?
No, sir. What we are suggesting is a court inspector. It should be the allocator should be the court inspector, not the.
I was hoping it's court inspector.
It's not, sir. So, and then the court inspector could have some people under him or her So those people could be assigned some police stations, specific police station. That will cut cost on network connectivity, that will cut cost on system, everything, sir. And then the court inspector knows where the IO is presently posted. Then so for example,
The address, yeah.
you can give directly to the IO.
Yes, it should go to the address's jurisdiction actually. Because if I send to Sadar SHO saying that a particular basti in Nanchi, he may not be knowing it. Okay, you just mark Nanchi SHO and it goes in private vehicles to be frank. So I would know it. There is no official vehicle which carries this summon. Some taxi driver is paid monthly or sometimes almost. So he takes it and it's his. But I'll tell you one thing, that these drivers, deliver it on time. I'm quite sure about this because I've gone deep into this. Why this summon? Because every time I was sitting in the courtroom, no information about summons. I insisted on getting the information. What happened? I'm not going to issue second summons unless I know what happened to my previous summons. So slowly I started getting information. Luckily at one point, there was even one driver who had come in some other case or something, I don't remember, who gave me all the details how these summons are taken, And to my finding, they were delivering it on time because of fear, right? So those processes were okay. The problem was the problem was in the release from the one police station to another and it coming back from there. So it should go to the address because if there's a basti somewhere in South Sikkim, it's a lesser known place, right? The SHO there would know better. In fact, he may even be knowing the person. Insofar we have such a small place. Okay, that solved quite a lot of problem in sending even proclamations. We are sending it to SHO Sadar because the case is up there. The place to be proclaimed is somewhere in West Sikkim. And by the time proclamation comes, 1 month is gone again.
One issue here is what is happening is because I am also part and parcel of
Yes.
meetings being conducted in ICJs,
Yes.
SCJs and all. So as of now, the 14 of our police station doesn't have the internet connectivity. Even the Malli police station doesn't have.
Yes.
So what they are doing is they are going to either to the Namchi PS or coming to the Rongpu or Jordan PS to upload their data. So if like the Elan sir was telling us that if that police station code is being taken for the service of the summons, then if it is not flexible and if you can't change the address, then all those police stations who are uploading data from other police stations, then all the summons will go to that police station only, Because Malli police station summons will go to Namchi first. Automatically it is happening as of now. So maybe that kind of flexibility, because I don't think within 2-3 years this problem will be solved, because 14 of our police stations, it's a lot of money.
I think the last meeting which I attended, they were talking about NIC line to this police station. I think they have got a fund for this, but that has to be maintained. And I told them, if the state doesn't give you money in future, this is going to come to a halt. The project, whichever, whether center, whether Eco's project or somewhere else, it's been from somewhere else, it's being funded, they'll just give once.
And one
So I told in the meeting, you need to
state government has already notified that e-summon rules also.
Yes.
So in that rules, I think
Because there was a lot of pressure from
yes, pressure from the Ministry of Law and Justice. So there is one rule which talks about the authenticated service of summons through emails, or there one more mode is given. So I don't remember, but I think SMS is, as of now, they have not considered SMS as one of the mode through which you can issue the summons. But email and one more thing is there. So whether we can directly send it to the addresses in the email, like in a...
So I have not read that rules, but if the rule says, then why not? It has to be considered as...
If I remember correctly, that email is considered one of the mode through which you can issue summons.
As the district courts got that rules. Judges.
It has already been notified. except the DC rules, everything has been notified by the state.
Hasn't it reached you or no? Okay, I ensured that it reaches to you all. And the lawyers also, I think it's important from them also. There's one rule.
If I've not received it, I can just ask for the Home Department and send it to...
No, sir, we'll just send the link to the district courts. Otherwise, sending papers and all, again, it becomes antithetic to what I am trying to do actually. So virtual courts, the file is still there with me for about 7 or 8 months. I'm just thinking what to do with this. We had thought of, making CJN Court East the motor vehicles court. Because only Mizoram and Sikkim always tell that we do not have this virtual courts because the vehicle challans are very less in our state. But I believe that if we have this, there will be a lot of vehicle challan cases that would come. So virtual courts would mean that the police would directly file it from there if someone has been caught for non-compoundable offence under Motor Vehicles Act, or if someone would refuse to compound, it has to come to the court. So there will be a virtual dashboards where the matters will be sent, and the court and the magistrate, in fact some states purely have virtual courts and virtual magistrates are humans there, but we can call them a virtual magistrates who are dealing with traffic challan cases on computer. Right? It comes to you daily and then you just mark it, and then summons goes to the person in mobile only, the accused person, okay? All the data has to be captured by the police, and then he can plead guilty. Usually it's pleaded guilty. In these cases, people would plead guilty even if they would come to the courtroom, right? Usually it's pleaded guilty, and that's how case is disposed of. If the case remains there in the virtual machine for quite a long time, either it's automatically goes to the court. Let's say Mr. Javian is CJN'd as a virtual court, okay, for traffic challan cases. All those who have pleaded guilty, paid fine, or whatever it is, what the next process is there, you will be dealing with it. The moment that is not solved in the virtual machine, it will be transferred, let's say, to Madam Rohini automatically or in some predetermined time, because if you have someone person and is still not coming or paying the fine, or if it's still not paying it online, then you cannot close the case. It has to reach a proper conclusion through judge. So he will be transferring that case to Madam Rohini, okay, do it. Or himself also as a CJN, different, not as a virtual court. So many of the states have this facility for dealing with traffic challan cases, especially most of the cases have a lot of revenue from traffic challan. We see, we always complain about, vehicles being checked and all. Of course, some kind of unethical practices does come in. But I would assure you that about 50% of the vehicles on the road do not have proper documentation. That is why it is checked. And it becomes one of the reasons of earning revenue, because you will find almost 1 out of 5 vehicles violating the law. So obviously you have to find that's a way of earning revenue also, and as a way of implementing laws. But people, I've been to the nearest place like Siliguri and all. I've never felt harassed. If I've done something wrong, of course they have stopped. And whenever they have stopped also in my private vehicles, I'm not telling I'm a judge, okay? And they do something, they check at it and they say, this is the fault in your vehicle, which you have not completed. But I have not been told, even when I am right, I have nothing wrong, I have done nothing wrong, still I have not felt that. I do not know how is others' experience, but they do agree on a lesser sum. They try to compound even the non-compoundable ones maybe. That's the only difference, but yes, they can stop you and check. Last time I saw one video where the person was saying, seat belt khole. The police would not know where you went. He saw you are not with seat belt. Now, can you tell police, just now I opened it. Still an offense. Of course, it may be his discretion to whether to accept your explanation or not. If he doesn't want, he's not bound to accept that we are just opened it for buying some vegetables. So there are a lot of traffic challan cases. If we can implement this, that's what I said, I'm stuck with that payment method. This requires an absolute online payment, and there's an insistence the money should go to the treasury. Now, some of you who may be hearing this for the first time, why I am unable to send to treasury is because SPS is not online bank, not at all. Remember, not at all. And it doesn't want to connect, because the moment I use it online, it can be accessed from anywhere. Online services, I mean to say. E-payments are Yeah, is it? There are these, third-party integrators like Grass, eGrass, but this cost a huge lot. This can be used as a middle partner to connect the client and the service provider. But we do not, most of the high courts or even the state governments are using this Grass as a middle platform to connect between the service taker and the service provider. We have SBI Collect, that's what I said. SBI Collect is its own domain. The money goes there, it doesn't go to SBI. Someone has to carry it from there to the SPS. Phase 1, 935 crore. Okay. Expenditure 639, quite less. Phase 2, till 2023, the amount was 1670 crores, expenditure 1668, a very good expenditure for the phase 2, right? Phase 3, the amount is not written here, but it's 7,201 crores, I believe. And Sikkim was allotted 10 crores something for financial year 24-25. We could spend 8 crores something. We had a saving of 1 crore something. But we achieved all our targets. Those were genuine savings. Under this year, in-step e-Seva Kendra is still being funded by the committee. Okay, scanners, all-in-one PCs now. I think we have given so much all-in-one PCs. I don't think courts nowadays say we don't want this. Please don't give. We have no space to keep. But we still have a lot to distribute. We will be distributing this. We have still kept in stock because poor places like ours, initially ICOs were not covered on the ICOs project, okay, except last financial year. So we need a lot of PCs in the High Court, so we have been distributing there. Once we are exhausted, we will be giving it to the district courts also. Camera, printer, document visualizer, this time we have got a very good document visualizer. I think paperless courts have received it or not. They have received it?
So not from this phase, but from the phase 2.
No, we are giving again for those paperless courts and live streaming courts. They have their own document visualizers. Contractual staff we have appointed so far, I think 3-4 for live streaming purposes, 3 for the High Court, 1 will come to the District Court Gangtok. We are appointing 5 more, we will be advertising soon for paperless courts on contract basis, and their salary is 50,000 per month, right? But for 1 year. DZ set was quite a problem. Now no one wants to use DZ set. All wants UPS, some higher kVA UPS. That's well and good. And I'm still trying to ask money for UPS this year. ICT new courtroom, digital signature token. I think for some it's still in process. For others it has been completed because High Court has already been given e-office software where the administrative files has to move e-office. But it's quite difficult because none of the personals, I think they are capable of using that. It's a very big software. For them we have obtained digital signature tokens. For districts also I think we have obtained.
The judges.
Not only judges.
Only this.
Okay.
We
No,
have-
one each I think we gave to somewhere south and west for OS and administrative officer. I am not sure. Yeah, is it true? We see new units have come. We see also new units. If we have already not provided to the district courts, we will be providing it. It's in the stock. Paperless and online courts. We included the Court of Judicial Magistrate actually under the concept of online court. Right? Live streaming, a new feature that will be coming. Very soon we will be starting live streaming in the High Court as well as the Court of Principal District Judge Center. It will be a little bit different because I'm getting the rules as of now because I think some of the contents of the rule need to be brought to the notice of our committee and the Honorable Chief Justice, which I feel is not required. Some of you know, using the recordings, I feel it has to be gone deep into and thought because if the recordings, using of those recordings are given at the drop of a hat, there will be a lot of petitions asking for it. Because I still believe what we speak and what we write may not match entirely, and if a lawyer loses a case, which has just said something else, or he has written something else. We need to minimize this. Otherwise there is going to be huge controversy. I'm still getting into that rules because I cannot completely dilute the model rules as well, right? So I'm trying to look for a balance and a good time for that to read it and try to see I don't want to copy paste that rules. That's right. So live streaming we will be having very soon. For districts, the evidences will not be live streamed. That's why there are some contradictions in this model rules. Somewhere I find, okay, it says it should be recorded but not live streamed. Somewhere I'm even feeling why it should be even recorded. I think I'll send it to the district judges and magistrates also for your comments on that model rules. Just like POCSO cases, right? We must somehow in physical papers. But once that live streaming starts in district courts, the rule says you can record it but not live stream. Somewhere I'm feeling why should we even record it if you are not to live stream it? Unless we have a system where we have no papers for these evidences and we rely on what we see in the video. So that is going on in my mind because I may be wrong also, it may need to be recorded. So I need to do a lot of work on that. So even today morning, it comes in my mind that live stream is very much delayed in our jurisdiction. I should have started long time back. So these rules, I have read it, still I feel I may be wrong. So I think I'll send it to district judges and magistrates to have comments on it. Those who have time, can you look into it and suggest something if you find it. Suggest it genuinely. No need to hide anything what you say. If it is not something which I should put up, I will not put up. Okay, it will remain up to me. But obviously that won't be, whatever judges will be writing will be from the application of mine. So just don't say, I have nothing to say. Of course, even I have said that at times. But because I didn't find anything to say on that, right? You are finding something that bothers you in those rules because your courts will be live streamed. See it that way. Okay? There's nothing to hide also. But looking into the legal provisions, which we have and whether such certain things will be conducive at this stage, we can always amend it for making it better in future. So yes, for lawyers also, I think since yesterday we have been installing the sound system in the High Courts. Yesterday I think court number 1 was completed. So once this live streaming is done in the High Court, so you all will have to speak in the microphone because that will be only catching it as a sound. Okay, what you speak outside microphone will not be taken by the machine which is live streaming. So I do not know, that would be your first time, our first time, how it feels and how we will be conscious or not about it. Actually we will not be. Once we are doing our work, we will not remember whether it's been live streamed or not.
Like in Guwahati.
Unless we make a mistake.
In Guwahati and even in circuit bench of Jalpaiguri.
Yeah, many concepts we have to. There's no way out. Otherwise, we get a long question as to why we have not started. Madhya Pradesh and almost of the district courts are also live streamed.
I have a problem with live streaming in the district courts.
Yeah.
This is my again personal view. Because you're reporting that the writ courts, I think it's still better because you just have your arguments of the lawyers, right? But when you are doing live streaming of trial courts, or the witnesses are deposing on, will there not be a threat perception?
Yeah, that's what. The rule prohibits it. The rule says you can record it, but not live stream. But what I saw as a problem for district courts is that, it gives you it gives the judge or the technical team there the option to pause. We'll be installing a software which will be delaying your live proceedings by 5 minutes or 10 minutes, how much we want, so that nothing improper goes out to the outside world. Suppose a real thing happened out here in real time for right now, right? It will be relayed only after 5 minutes. It will not go to the public domain instantly. Okay, so the live streaming there will be actually a pseudo live streaming of 5 minutes delay. It's a relayed version. So that if you stop something, it will not go. Otherwise, if you allow it live, someone may throw or sues or whatever. The lawyers may fight among themselves out there, right? Catching your callers, those are not things to be. So it's a possibility. So yeah, I understood. We will.
Like even let's say, for instance, even seizure witnesses, they give independent evidence before the court and gets live streamed, irrespective of the timing.
Yeah.
And there is a conviction based on the seizure. Alright? Will the family members of the convicted person not voted against the witness? I think
Yes,
that
sir.
becomes a little dicey.
No, that's why the rule says that trial court's evidences, cross-exams, nothing will be live streamed. The rule prohibits it, right? But I think it's for the time being, it's being said. So I'm looking a little bit ahead to these rules so that, we don't have to amend it again and again, something new might come. So my view initially, as of now, is why should we even record it? Yeah. So I do not know, the purpose is not known why it is being recorded even we are not live streaming it. There is a usage chapter, how to use these recordings, right? But wouldn't there be a conflict? So I'm looking from every angle, okay? The model rule says so. We are not bound by model rules, we can always change it. But the core, it says, it's a guiding rule coming from Honorable Supreme Court. We need to look into that also. So how to balance it, and it requires a good thought and, a free time for you to only work on that. That's why I kept it aside. So, but
there is a
but,
provision for pixelation of faces.
yeah,
But then
those for recordings.
technical.
Yeah. No, those all can be done. Technically, that is, if it is just for recording, we can always pixelate it later on also, right? If it's not being live streamed. Because what you see and what those people see in the courtroom will only be recorded. Okay. Now misuse, the possibility is always there. So I'm trying to insert in that rule who would be accountable for misuse. What usually happens is, these are my views, you all can look into it. What if the recordings are leaked? Because the rule also says that we can prohibit certain recordings from being shown, even though it was live streamed. To my understanding, live stream is for today, it's over. Because if you see YouTube, you will find it's recording. Even if it was live streamed yesterday, you will still find it out there. So what I'm thinking is, okay, let's not do that. It will remain there in the YouTube as long as it is live streamed. Can you remove it from there after it is live streamed? That also I'm looking into it technically whether it can be done. I've been told it can be done, but certain problems they were citing about it. And the next thing is, as you said, if it gets leaked, who is to be blamed? The judge or the court manager? What I'm trying to insert is, of course, the first responsible person for that as an administrative head will obviously be the district judge, why it happened, right? But the actual perpetrators would be punished and not someone else who had no role in leaking it. So I'm trying to include that also so that you can fix accountability. Then there is always a chance of because those recorded and not live streamed should not be leaked.
The system gets hacked.
Yeah, there is always a possibility.
And there's the issue of storage also, extra storage.
Yeah. So storage issue is coming up. YouTube is providing certain storage capacity, but what we are thinking is, storage in today's era, it is not really going to be a problem. The only thing is your task will be more. Employees' tasks, they are more. I think the server which we are bringing in High Court is of 500 TB. 500 TB is a huge one. We are trying to, keep the local data in those servers. So yes, that's why I have not, just gone with those rules, and I could have easily done, okay, to be frank. That would save my time, that would save my headache. Every other places have modified model rules without looking into it. So, it's just the same thing. It's a very good one, but I still, I've been in the course, and I still feel that something may have to be done on that, or, it's not just copy paste and notify it. Let's apply the mind. That's what is in my mind. Trial courts evidences are not being live streamed, and the commercial courts, I think, why I chose the PDJ court is because it's a commercial court at Gangtok where we can start something, quite a lot of cases. So commercial courts usually there will be submissions and all. Evidences need not be, but I have requested the PDJ he can live stream the arguments, right? And the rule also says it should focus the judge and the lawyers. The audience, media persons and all, as far as possible, do not capture them. Okay? So those rules are there. You all can even download it and see if the model rules on live streaming. I need to notify it by June at least. NZDC, we all know all the data are there. Now, as I said, hacking also, there are hackers who do it for the purpose of entertainment. There are hackers who need certain things from there. Still, we are safe about it. But to avoid that, at the High Court, we are installing a hardware firewall also, because all these things are required, which minimizes unauthorized access to the systems. But still, it's not a foolproof. As of now, the firewall is there with us. If we keep in our servers at the High Court level, then we can do something about it. But of course, hacking cannot be ruled out. But so far as of now, they may not hack saying that, okay, this is Sikkim, let's hack that. On the general hacking processes, we may be a part of it as of now, but we still cannot rule specific targeting also. People may experiment out here in the place which is least secure. We are least secure, I admit that. Anything can be taken from us as of now. Because we have not faced it, right? Once, even all the institutions, like there was an attack in AIMS hospital and all, they have not faced it, they did not know it. Probably now they have a better defense system which they have installed. These are all not required, it's in very detailed, right? So we have still 10 minutes, anything before we end this session. Request the judges to please see this live streaming on this slide. And from a peer point of view, not only we as judges, but looking into what very object of live streaming is to let the world know that you can see anything about the open court. The only problem with why we are restricting this is because it's in electronic form. Otherwise, anyone can come to the live court and see whether it's the witness or the accused, or I can say anything out there. So, without violating the concept of open court and the need and the objective of live streaming, we need to see these rules. Some of them would be uncomfortable to the judges, but that's how it is.